Good evening, everyone. Welcome to Juris Root. Today we'll be talking about criminal intimidation given under Section 351 of BNS. So this is given under Chapter 19 of BNS, and we'll be talking about this topic today. So coming to criminal intimidation. So in the previous classes, those who are attending the classes, you must have read about extortion. So criminal intimidation is slightly analogous to extortion. In extortion, what happens? The general motive or the object of extortion is to extort money from the victim, right? But in case of criminal intimidation, the main object is to induce another person or threaten another person to do something he is not supposed to do or not to do something he is legally entitled to do, right? So we'll be discussing this in detail. Coming to the legal definition of criminal intimidation, you can see Section 351, subsection 1 says that whoever threatens another by means with any injury to his person, reputation, or property, or to the person, reputation of anyone in whom that person is interested, with the intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do, as the means of avoiding execution of such threat, commits criminal intimidation. So you can see there are certain key words of this section, and in fact in BNS there are always key terms and key words which you have to remember. Okay, so whoever threatens another by any means with any injury to his person, reputation, or property. So there might be injury to three things. Okay, person, property, or reputation. PPR. Okay, just a illustration for this definition. A, for the purpose of inducing B to resist from prosecuting a civil suit, threatens to burn B's house. A is guilty of criminal intimidation. So what A does, so in this case, B has filed a civil suit against A. So now A is threatening B, saying that if you do not withdraw the civil suit, I will burn your house. So I will burn your house is the threaten that A is giving to B. So this is the conduct of A towards B, by which he is threatening B to burn B's house if he is not withdrawing the civil suit. Okay. So coming to the essential ingredients, there must be threat, like we read before in the language of the section which is given under 351. We read there must be threat. Threat may be conveyed by words, signs, electronic communication, or conduct. In the previous illustration we read about conduct. So the conduct of A was such that he is saying by words to B, I will burn your house if you do not withdraw your civil suit. Okay, he is threatening B in this case. Similarly, what is the nature of injury? Injury may be to person, reputation, or property. You can remember this like PRP, person, property, or reputation. Okay, this might be the nature of injury. Or to the person or reputation of someone in whom the victim has interest. So, A is threatening B in this case. A might threaten to B's son, who is C. Okay, A might say that I will throw C from the bridge into the river if you are not withdrawing the civil suit. In this manner also A can threaten B by threatening to injure the person, property, or reputation of someone in whom the victim is interested. So in this case B is the victim, B's interest is his son C. So A might threaten to injure C, who is the interest of B, and thereby uh, completing the offense of criminal intimidation. Okay. Now the third ingredient is intent. So in all the offenses under BNS, you must have come across this sole important thing, that is mens rea, intention, malafide intention, and that is very important ingredient of any offense. So there must be intention and mens rea. So the threat must be made with specific intent to cause alarm to the victim. So therefore mens rea is an essential and it cannot be presumed. Okay. So there must be intent to intimidate that person to injure the property, reputation, or person of that particular victim. Okay, in that manner, there must be intention to commit that crime. All right. Now, coming to the fourth ingredient, it consists of coercion. So, the alarm must be intended to compel the victim to do an act he is not legally bound to do. So, there are two instances in this case. So, first one is forcing the victim to do something which he is not legally bound to do, and forcing the victim to do something, not to do something which he is legally entitled to do. Okay, you have to remember this. This is very tricky part. So, compelling the victim to do an act he is not legally bound to do, or to prevent him from doing an act which he is legally entitled to do. So, he is legally entitled to file a civil suit in the previous illustration. So, what you are doing, you are saying him that withdraw the civil suit that you have filed. So, you are forcing him to withdraw the civil suit which he is legally entitled to do. Or for example, you are forcing someone to beat another person. So he is not supposed to beat another person, but you are compelling that other person to beat another person. Okay, in that manner you are threatening the person. So these are the four ingredients of criminal intimidation: threat, nature of injury, intent, mens rea, and coercion. Now coming to the judicial interpretation and key principles. On the basis of intent, the case law is Manik Taneja versus State of Karnataka, 2015. In this case, it was said mere expression of grievance or criticism does not amount to threat unless it causes any kind of alarm. Okay, so just because you are expressing your criticism, or you are just criticizing a certain thing based on your ideology, doesn't mean that you are criminally intimidating somebody. Okay, unless and until you're threatening that person, or you're thinking of injuring that person. If you're just expressing your problem, or you are just stating any kind of criticism, will not amount to criminal intimidation. Okay. Another case was Ramesh Chandra Arora versus State, 1960. It said that injury to reputation is sufficient even without physical harm. So there need not be physical harm all the time. Injury to reputation is also sufficient. For example, A is saying to B, if you don't do certain work, then I will publish bad things in your name on social media. Okay, so publishing false things relating to B on social media, by doing this, A is committing criminal intimidation to B. Okay, A is committing this offense of criminal intimidation. How he is committing the offense of criminal intimidation? By injuring the reputation of B. So by publishing certain things against B on social media which are false, so by doing that, the reputation of B will be injured in that case, and he is forcing B to comply with his terms. Okay. Now there is a very thin line of difference between defamation and criminal intimidation. Do not confuse yourself with defamation. Defamation is publishing, defamatory statements against another person. That is different. But in this case, there is injury to reputation and there is threatening. Okay, threaten and injury to the reputation, property, or person of another person. Okay, that is criminal intimidation. By doing that threatening to do that injury, one person is compelling the other person to do something he is not supposed to do, and to omit from doing something which he is legally entitled to do. Okay, these two are different things. Now coming to the third case law, Amitav Adhar versus NCT of Delhi, 2000. The threat must be directly linked to compelling the victim's conduct. We read about victim's conduct, and that is directly connected to the threat. So what is the key principle in this case? Execution is not necessary. B need not have published false statements against B. In this case, execution is not necessary. The offense is complete upon the communication of the threat with the required intent. So the fact that A is communicating to B that I will publish this in your name, or the fact that A is communicating to B saying that I will burn your house, that itself is completing the offense of criminal intimidation, and the threat does not need to be carried out. Okay. Now, what are the boundaries of law? What is not criminal intimidation? Now that you know what is criminal intimidation, you must know what is not criminal intimidation. So, mere abuse or angry words without any intent to cause alarm. Okay, just quarreling between two people, between two friends, or fighting between two people. That will not amount to criminal intimidation. Just you are fighting with someone or you are abusing someone, that doesn't mean it is criminal intimidation. Similarly, ideal threats made without coercive intent is also not criminal intimidation. It may be lawful if there are legitimate warnings or lawful demands, expression of dissatisfaction or protest. Legitimate warnings. For example, A is a lawyer of B. B is not paying the payment to A. Okay. If B has not completed the payment to A. So A is saying to B, if you don't complete the payment, I will go and file a suit in your name. So this is not a criminal intimidation. This is legitimate warning that you have not paid my fees. Please complete the payment or else I will file a civil suit in your name. Okay. So there may be legitimate warnings, that is lawful. Expression of dissatisfaction or protest, that is also lawful. If you're doing any protest lawfully, any hartal or any band you're doing in a very lawful manner, then that is not criminal intimidation. There was a case, I think it was against CPI versus, it was I think Amar Singh or something, CPI versus Bharat Kumar. Okay. CPI versus Bharat Kumar. In this case, the band or the protest that the petitioner wanted to conduct the protest or band, it was dismissed by the Honorable Court, stating that such band which they were thinking to do was, likely to amount to criminal intimidation because it was of a aggravated form. So that might lead to criminal intimidation. That is why court denied that kind of bond. So if you are doing any kind of lawful protest, that is allowed, or else if it is likely to harm the public or it is likely to threaten anybody or to cause criminal intimidation, then that is not allowed. There is another noteworthy explanation you have to remember. A threat to injure the reputation of any deceased person in whom the person threatened is interested is also within this section. Now, for example, um, A and B are there. So B's father is dead. A is threatening B in B's father's name. So even if B's father is dead, A cannot cause injury to B's father's reputation. Okay, now for example, taking the example of injury to reputation, A cannot cause reputation injury to B's father just because he is dead. Even if he is dead, he will be held accountable under this and he will be accused of this offense, that is criminal intimidation. So causing a threat of injury to any deceased person in whom the victim is interested is also an offense under this section. Now, what is the hierarchy of punishment under this section? The hierarchy of punishment is easy. So earlier what happened under IPC, there were few sections like 50, I think 6, 7, 506, 507 under IPC, and many other sections were also there which dealt with the punishment of criminal intimidation. But under BNS, what they have done, they have simplified this and they have brought all the punishments under one simple section, that is 351. So section 351 subsection 1 to subsection 4. Okay. Talks about the punishments and about criminal intimidation. So subsection 1 talks about criminal intimidation, causing threat of injury to any person, reputation or property of any person. That is under subsection 1. Now subsection 2, 3, 4 talks about hierarchy of punishment. So subsection 2 talks about simple intimidation. Simple intimidation means general threat causing alarm to any person, reputation or their property. So simple intimidation, it is simple in nature. So 2, subsection 2, 2 years. This is how you can remember. Subsection 2, 2 years. So punishment will be up to 2 years imprisonment. Similarly, aggravated form of intimidation under subsection 3. So if you are threatening someone to cause death or grievous hurt or destroy their property by fire or commit any major offense, then the punishment will be up to 7 years of imprisonment. So 3, 7, odd numbers. Okay, 2, 2, 3, 7. So 7 years of imprisonment in case of aggravated form of intimidation. Similarly, anonymous intimidation. Now, anonymous intimidation means without revealing your identity. Okay, so made anonymously or with concealed identity. In this case, also 2 years imprisonment in addition to the punishment under subsection 2. So this one, anonymous intimidation, is additive in nature. Okay, this is not alternative in nature. This is additive in nature. Additive in nature means in addition to subsection 2. So in addition to the simple intimidation, another up to 2 years of imprisonment can be given to anonymous intimidation if caused. Okay, so this is additive intimidation. So anonymous threats carry an additive punishment due to their higher psychological impact and difficulty in detection. So it is basically wasting courts time, energy, and it is wasting the time of other authorities also. Therefore, anonymous intimidation is in addition to the simple intimidation punishment. Okay, this is the hierarchy of intimidation. Now coming to section 352. 352 talks about intentional insult. Okay, insult is the main ingredient here. Intentional insult with intent to provoke a breach of peace. Now, what is the anatomy of this particular section? So the act. Okay, what is the actus reus in this case? Whoever intentionally insults in any manner. Whoever intentionally insults in any manner and thereby gives provocation to any person. Insults gives provocation to any persons, and the intent, the mens rea is intending or knowing it to be likely that such provocation will cause him to break the public peace or commit any other offense. So he knew, he had the intention. So he had the intention, he had the knowledge, and in that manner also he insults another person and provokes the other person to break the public peace and commit an offense. Then that person will be held under sorry then the person will be held under section 352, which talks about intentional insult with intent to provoke a breach of peace. So insult can be of any manner. For example, if you are calling somebody as pig or dog or anything, you are insulting that person. You are creating a environment of toxicity. So you're intentionally insulting that person and you're provoking that person. So in that case, you are trying to violate the dignity of that person and provoking that person. So in that case, the imprisonment will be of 2 years or fine or both. Intentional insult to break the public peace. Okay. Section 353 talks about statements conducing to public mischief. What is conducing? It is leading. Conducing means leading, facilitating. Okay. So whoever is giving any kind of statement which is leading to public mischief, that person will be held liable under section 353. So what does this constitute of? The act of making, publishing, circulating false statements, rumors, reports, including via electronic or online means. So if you are making, publishing, circulating false statements, rumors, reports via you are doing this thing via electronic or online means, then you are doing the offense of public mischief. Okay, this is under section 353, statements conducing to public mischief. So subsection 1 says that threat to state and public order. So in order to induce the mutiny, cause alarm leading to offences against the state or incite community conflict, then imprisonment will be up to 3 years or fine or both. Okay. So subsection 1 relates to threat to state or public order. Subsection 2 relates to promoting enmity through false information. Now someone is circulating nowadays someone is circulating something over say WhatsApp or any social media. Okay. And by doing so he is circulating in all the groups a certain fact which all may not verify. So by reading that he creates a sense of enmity between the people, and he promotes enmity between the people. So if someone is doing that, the person will be held liable under this section 353 because he is promoting enmity through spreading false information. So in order to promote enmity, hatredness, ill will between groups on the ground of religion or race, etc., imprisonment will be up to 3 years. Okay. Then subsection 3 talks about aggravated form. Now this, why is it aggravated form? Because offense under subsection 2 committed in a place of worship or during religious ceremony. Now in place of worship or religious ceremony where it is going on, if you are doing this offense, which offense? Offense under section 2, subsection 2 means subsection 2 talks about promoting enmity. If you are promoting enmity in any place of worship or any place where religious ceremonies are going on, then you will be liable under subsection 3 of 353, and it will be an aggravated form of punishment ranging up to 5 years of imprisonment and fine. Why this is aggravated form of punishment? Because generally communal riots and all kind of aggravated form of violence takes place due to such promotion of enmity between people and spreading of false information between people in places of worship. Okay. They take the advantage of religious places and places of religious worship and sanctity, and by taking the advantage of the religion of the people and caste or race of people, they promote enmity between people. So if you are doing that in any place of worship, you will be held liable under subsection 3 of section 353. Now there must be defense to prove that certain act is not coming under criminal intimidation. So what is the defense? So what are the exceptions that you can take? So an individual is not guilty of an offense under 353 if they can establish the following conditions. Okay, if they have reasonable grounds to believe the information was true. So they had enough reasonable grounds to believe that such information was true. That is why they circulated the information. Okay, if they think like that, then it is okay. They will be coming under the exception under this section because they were not having intention. So as we read, intention is the main gist of any offense, mens rea. So if there was no mens rea and they did it in good faith, then it is excusable. They acted in good faith. They lacked the prohibited intent to cause mutiny, alarm, or enmity. They did not have the intention, like we talked. Okay. So this was about section 353. Now coming to section 354. Okay. 354 says that inducing belief of divine displeasure. The essence of the offense is the exploitation of religious or supernatural belief to control another person's conduct. So like I said before in 353, the religious background of people are generally taken as, taken advantage of. So if you are exploiting someone by taking their religious belief, and you are exploiting that person by saying something which will give them divine displeasure, okay, by the gods or anybody that they follow or any faith that they follow, then you will be committing offense under 354. So what is the act? The voluntarily causing someone to do an act they are not legally bound to do, or to do omit an act they are entitled to do by making them believe that they will suffer divine displeasure. So you can understand this with the help of an illustration. A sits dharna at Z's door to make Z believe that he is an object of divine displeasure. By doing this, A is making Z believe that if Z is not doing something, he will invite divine displeasure. The gods will be displeased and they will be cursing him. Okay. Similarly, there is another illustration. A threatens to kill his own child to make Z believe he would become an object of divine displeasure. Okay. So by doing this, he is making Z believe that he is also becoming an object of divine displeasure. Like they say, usually they tell that bali dena hai. Okay, that kind of thing. So A threatens to kill his own child to make Z believe that he will become an object of divine displeasure. So if you are putting something like this in someone's mind, then you will be held liable under this section. So the imprisonment will be up to 1 year or fine or both in this case. Now coming to the last section, which talks about annoyance by intoxication. Okay. So what is the state of the person? The person is in a state of intoxication. Say A. Okay. A is completely intoxicated. He appears in a public place or a place of trespass. Suppose A is standing on a highway. Okay. And he is completely intoxicated. He starts dancing. He creates all kind of nuisance on the road. He annoys the passerby. He annoys the people or passenger who are going through the road, and he behaves in a manner that causes annoyance to any person. So he is in a state of intoxication. He is on a road or somewhere where public is there. Okay, public place, and his conduct is so bad that he is causing annoyance to people. In this case, he will be held liable under section 355, that is annoyance by intoxication. Okay. The punishment is simple imprisonment up to 24 hours or a fine up to 1000 or both with community service. So 24 hours is the maximum punishment of simple imprisonment that he might be punishable with. Okay. Or he might be also punished with 1000 rupees fine or both or community service. So this was all about criminal intimidation and annoyance. So see you all in next class, and those who are attending classes of UGC NET or those who have taken subjective classes, you can contact us in any case of doubts. Okay, thank you so much for attending the class.